A Wisconsin Supreme Court ruling this week changes how police officers can justify a traffic stop.
The ruling comes after a man was pulled over for having a GPS on his dashboard and an air freshener hanging from his rearview mirror. Now, police said it was obstructing his view. During the stop, marijuana was also found in the man's car. While the lower courts ruled the items on the dashboard were not illegal and therefore the stop and search violated the man's rights, the state Supreme Court's ruling this week says officers now have some leeway when it comes to interpreting traffic rules and regulations.
In this case, what the officer thought was that a pine tree air freshener hanging from the mirror was a violation of the law. And the Supreme Court said they didn't think it was clear that that was unlawful and that it probably wasn't unlawful, but it wasn't clear at the time, so the officer's conduct in pulling the person over for that was not objectively unreasonable, and they were not going to suppress the evidence.
News 8's Kyle Dimke tells us how this ruling could change things for both drivers and law enforcement.
State Trooper Ryan Smith has 15 years experience patrolling Wisconsin roads.
How you doing? Trooper Smith State Patrol, so driver's license.
He knows pretty much every traffic law there is in Wisconsin, one being that a driver can't have anything blocking their view of the road.
I stopped you for that view obstruction. They can't have stuff suspended off your rearview mirror. It kind of obstructs your view of the roadway.
A recent ruling by the Wisconsin Supreme Court suggests, however, that the definition of obstructing your view is up for debate and can be different between driver and officer.
Obstructing your windshield has never been clear, and there's been different rulings in different courts all over the state.
The state Supreme Court's ruling says that if a judge believes an officer's interpretation of a law gives that officer reason to believe you are breaking the law, then that officer has the right to pull you over, even if you weren't actually breaking any laws. And anything found in your vehicle during that traffic stop can be used against you in a court of law.
I think the interesting thing about it is that somebody can be pulled over for a mistaken belief about the law, and the stop is still potentially going to be found to be okay.
Lawyer Joe Veenstra says the new ruling leaves a little too much room for interpretation, and trial court judges are going to be left with some big decisions to make because of it.
One court might rule differently than another about that. It's really hard to know.
Reporting in La Crosse, Kyle Dimke, News 8.
The Wisconsin statute says no one can drive with any object placed or suspended in or on their vehicle that would obstruct the driver's clear view through the front windshield. And this law is still in effect. Just last year, the Wisconsin Supreme Court ruled in the opposite favor on a similar case, saying if an officer makes a mistake, criminal evidence found during a traffic stop would not be used against that person in court. The reason for this change now is to be in line with the U.S. Supreme Court decision.